I'd like to thank everyone for joining today. My name's JP Offret from George Mason and director of the Center for Assurance Research and Engineering and also co-director of the Center of Excellence in Government Cybersecurity Risk Management. I have a wonderful talk today from Gary Rinkerman on a very, very current topic on civil and criminal litigation related to AI. Gary is a founding partner at the law firm of Pearson Ferdinand, also an honorary professor of intellectual property law at Queen Mary University School of Law in London, and a member here of our Center for Assurance Research and Engineering senior fellow, and also on the board of our CRC center. Gary writes extensively on AI intellectual property, and in the early 80s, he was co-founder and editor-in-chief of the Computer Law Reporter, one of the first publications to deal exclusively with computer technology and related legal issues. Gary was also first chair litigator as a senior investigative attorney at U.S. International Trade Commission in the early semiconductor patent and copyright cases labeled by the media as the chip wars. So with that, tremendous appreciation for Gary and his talk on a very current topic. And so, Gary, thank you.
Okay. Well, thank you for that wonderful introduction. I'm thinking of changing it though to just saying Gary was born before the internet, and just leave it at that. But anyway, thank you all for attending. I'm dressed pretty casually. I'm sorry about that. I'm in Florida. The air conditioning isn't working, and wearing a suit right now is the last thing on my mind. If you need to see me dressed like that to see the gravitas of the person, you can get on my firm website, and there I am in the obligatory suit and tie. But let's get busy with the presentation. I want to do a few housekeeping things first. The way I construct the slides or constructed these slides um, are a little bit different than most PowerPoint slides. You'll see they're very dense with information and illustration. What I wanted to do was create something that you can keep in your file and pull out and see almost the full context of what I'm discussing. I got onto a website the other day and looked at some slides, and they were a couple of years old. They weren't mine, and they just had, names of cases, which really didn't help very much. So I'm trying to give you a little more narrative. In creating that narrative, I decided to illustrate the slides to give them a sort of visual punch, and signed on to Midjourney and began playing around with that system. And I was a little torn by that because the images are sort of whimsical, and the subjects we are discussing are not. They're very, very serious subjects, and I do like to use illustrations, but the illustrations, if I had used ones that kind of coordinated with the seriousness of the matter, they would be kind of hard to look at. They're kind of like Andy Warhol's series of car crash images. They're very difficult to deal with. So I went with the whimsical approach. I have a little reservation about it, but let's see how it works. And I also like the idea of using AI in a positive way to create these slides, because we're going to be talking about a lot of allegations that there are negative aspects of AI that need to be addressed and addressed promptly. Um, so I wanted to show that AI in a positive light, and I apologize to all my copyright students and colleagues. We'll talk about the copyright aspects of Midjourney in some other context. So let's go forward to, this is the first slide. I created an alternative slide. This slide shows you my first attempts at Midjourney after I paid my $10 per month and spent a few minutes illustrating an angel chatbot, a devil, a seductive chatbot, and a violent chatbot, and then a chatbot as a defendant. So this is my first attempt. And if we go to the second slide, you'll see how quickly my options for expression evolved, and the I changed sort of the title of the presentation a bit. The floodgate opens. Is your AI a guilty party in civil and criminal cases? And new trends and potential liabilities. Now, we are going to be discussing in this particular instance these chatbots that are anthropomorphic and they are generative. So they create the illusion of a relationship with the user, of either a friend, mentor, some sort of authoritative figure, perhaps a seducer, and more. And they create this personalized relationship. So we're kind of talking about the cases that deal with that at the moment. Then we'll go into Chat GPT, which is a little more expansive. But one of the serious concerns is that a lot of principles that are being developed in what would be described as worst case scenarios may end up floating back into more benevolent AI type endeavors. So you see that some of the legislatures and academic thinkers are beginning to sound the alarm that these cases that deal with very, very sad events might end up setting precedent that actually stifles the development of AI and burden it with litigation and liability that we might not want as a society. So here we have this, the floodgate opens, and let's go to the next slide. Now, here I put for you, because we're going to be dealing with issues involving suicide and mental disturbance, I wanted to put this notice that I also put in the article that is the foundation of this presentation. If you know someone who needs help along those lines in dealing with a mental crisis, please give this information to them. If we save one person or help one person out, that's way more important than anything else we can do today. So here you have the notice, um, then the bio, and then my note on the slides. The copyright notice for my copyright friends. Please look at that carefully. It was designed with some special copyright and IP aspects in mind, and it's rather unique. And then I dedicated this to my friend, the poet Jim Carroll, because we'll see later he figures a little bit in the discussion. And then, of course, I have the obligatory disclaimer: this is not legal advice. It's not to be associated with any sort of organization that I represent or work with or any client. It's just my own. And please be aware, as we discuss the cases and allegations, we're not taking a position as to whether someone is guilty or if the facts are necessarily true. Maybe on appeal they'll turn out to be something different, but we're identifying the trends and the current state of the allegations. So keep that in mind. I don't want to indicate someone's guilty of something when they certainly have not had their day in court yet. Okay, now let's go to the next slide. All right, now this is the where the rubber meets the road. We're going to start talking substance. In 2025, a case came down from the Middle District of Florida, a federal court, Garcia versus Character Technologies, Inc. This case was sort of a floodgate that opened, and it was a matter of great attention on the part of those who participate in the AI industry. You'll notice the title of the case, though. It's not just the company being hauled into court. It's Google as a component supplier, and there are individuals. We're dealing with a potential individual liability here. Keep that in mind. That's going to pop up later when we start talking about other aspects of these cases, including the criminal investigation. So this case comes along, and the core allegation in Garcia is that the character AI personalized chatbot content contributed to the decision of a 14-year-old user to commit suicide. The character AI bot was emulating a character from Game of Thrones and having a dialogue with this particular teenager. And we'll see as we go forward what that allegedly resulted in. The opinion was issued on what's called a motion to dismiss, a 12B6 motion. So it isn't the final decision in the case, although it made some legal conclusions that would shape the case tremendously. But just know that we didn't even have a response. We had a motion to dismiss, and the judge is considering that motion and determining whether the facts are sufficient to go forward and have a litigation, and whether or not the law is sufficient to continue as well. So the Garcia opinion, which was issued in 2025, has been characterized by one writer, Aaron Mack of Politico, as AI's big tobacco moment. Now, there are a lot of things about Politico I disagree with, but I think Aaron is correct here. I think what he's saying is this woke everybody up and said, okay, now we're going to begin to recognize certain risks or alleged risks and to allocate responsibility for them. So again, the case was a tremendous opener of a floodgate. And the first point I want to talk about from Garcia is the judge's conclusion that the character AI chatbot may be considered to be a product subject to product liability law rather than merely as a service or an instance of expression. So why is this product service expression dichotomy important to us? Let's go to the next slide. We can spend a whole law school course on product liability and probably not cover the whole topic. So we are just going to skim the very, very top of it here. But if a chatbot is characterized as a product, there is a well-developed and some would say highly punitive set of product liability laws and regulations that apply. So as Walter said to Smokey in The Big Lebowski, you are entering a world of pain. Now, most states within the U.S. recognize that there are claims, product liability claims, for defective product design, defective manufacturing, or ineffective warnings. And of course, there's the other typical claims such as negligence, gross negligence, and the like. And you can multiply claims as pretty much at a whim. But in any case, these are the core concerns, and we'll see them pop up in our cases that we're going to talk about. And also, there's regulatory oversight on the state level and federal level. For example, there's the United States Consumer Product Safety Commission, and they're charged with evaluating whether products are unreasonably risky or whether they need to be recalled. And they also do this commission, they do research and product related illness and injury. So it's a pretty powerful organization. We'll see how it pops up later in this context. Now, in product liability actions, you also have the possibility of punitive damages. Since it's a tort, that means that you can multiply the damages if indeed there is behavior on the part of the defendant that merits that. And we issue or we the courts will grant punitive damages if they feel it will deter others from acting in a similar way, or perhaps the defendant was particularly egregious, grossly negligent, or something like that. So we often see punitive damages issued when the defendant knew that its product posed a danger to users, but failed to warn about those dangers. The defendant intentionally sold a defectively designed product, or it failed to conduct adequate safety and research into its product before it released it onto the market. I mention these just in passing and in summary because think about these as potential remedies for the civil cases that we see brought by the private plaintiffs. The liability can be astronomical or catastrophic in some instances. Now let's move on. All right, now what happened in the Garcia case was Character Technologies and the other defendants made a motion to dismiss, as I mentioned, and one of their arguments was that the First Amendment prohibits tort liability for speech. Now, there are exceptions to that, by the way. For example, defamation, trademark infringement. Those are torts that the First Amendment has a bit of a role in, but ultimately, if it's defamation, it's defamation. If it's infringement, it's infringement, unless there's an appropriate defense. So in any case, what the defendants here are arguing that this chatbot, this AI, is merely producing information, which is the equivalent of speech, and the First Amendment should bar this wrongful death action by a tort law because someone reacted to speech provided by character AI. And so that was one level of attack. Now, there's a little bit of nuance to that in that if we begin to really hamper speech, burdening it with tort liability when it doesn't fit one of our normal categories of defamation or infringement or the like, are we going to impact culture? Are we going to impact people's abilities to write novels that pick violence or make movies? So there is this sort of not only political aspect to it, but creative aspect. And my friend Jim Carroll, wrote a book called Basketball Diaries, which was sort of an autobiographical novel, and they made a movie out of it, and it keyed off a statement in the book, but that movie showed a graphic depiction of a shooting in a school. Later on, the Columbine shooting looked particularly like that shooting. The characters wore these long coats and whatnot, and I knew what Jim went through. I mean, the agony of being accused of being somehow creating that when all he did was write a novel that wasn't even as violent as most Stephen King novels. So anyway, we worry about maybe burdening too much our culture's ability to engage in speech. And the second defense that was raised, that even if the plaintiff's claims are not barred by the First Amendment, the provision of this content is a service, not a product. And once you're a service, you get outside that whole gestalt of a fixed product liability law and you're back into negligence and maybe some statutory causes. But most companies would view that, as these did, as less burdensome and dangerous to them than product liability law. So these two defenses were put forward. Now let's move on to the next slide. Now here we have the judge. This is Judge Anna Conway. She issues the Garcia court opinion. And she does properly say courts generally do not categorize ideas, images, information, words, expression, or concepts as products. Again, that keys back into our First Amendment consideration. And she cites a case and she says, yes, there is a case involving Mortal Kombat. It comes out of Connecticut and it was dismissed because the plaintiff there alleged that her son was stabbed by another individual who watched Mortal Kombat and was unduly influenced by the violence in there. And the court basically threw that out and said, look, these are intangible, expressive ideas in a video game, work of art, a work of expression. You can't come and assert this type of tort based on that. But Conway kept going, and she said, in Florida, we have a case, and it's against the Lyft company. And she said, in that case, the plaintiff was struck by a Lyft driver, and the court concluded that the Lyft application was a product under Florida law, and it was defective in the way it operated, I guess, to assign or drivers or choose drivers or whatever. So she said there are instances where something that does produce content, that does produce what looks maybe like a service, are in fact products. And she said, accordingly, character AI is a product for the purposes of plaintiff's product liability claims, so far as plaintiff's claims arise from defects in the app. Now, that's important. The claims arise from defects in the app itself rather than the specific instance of expression produced by or within the app. So it's kind of a very subtle distinction, but it's one to keep in mind. And that's where the app becomes a product. And that's where we start applying the product liability law, as Judge Conway did here. By the way, she recites the facts of the case, and they're brutal. They are really, it's hard to read that case about this poor 14-year-old. And some people say bad facts make bad law. Maybe so. But in any case, I urge you to read the article I wrote of the case itself, and you'll see what I'm talking about. Okay, next slide. All right. In addition to the manufacturer, rather the provider of the character AI, the defendant list included Google. And the reason why is that under product liability law, a component supplier of a product may be held liable if that component was defective and it caused the injury. The component supplier can also be held liable if it participated in the integration of its component into the product, and that product turned out to be defective and caused harm. So here, Garcia alleged that character AI was designed and developed on Google's architecture because Google contributed intellectual property and AI technology to the design and development. So there we have the component, the AI. Let's put that to the intellectual property. I think we could put that to the side, but they did contribute technology, and they alleged that Google substantially participated in integrating that technology into the character AI. And without Google's provision of the accelerators, the GPUs, and the TPUs to power that character technology, there wouldn't be any product whatsoever. So Google identified the anthropomorphic nature of the LLM, large language model, integrated into the character AI product as coming from Google, and this was in part of the defect of the product. It caused various effects on users that were injurious. Now, so accordingly, the court said, in light of the above, Garcia sufficiently alleged that Google is liable as a component part manufacturer. So this is heavy. Now we've got Google as the component supplier, but it gets worse for them. Let's move on to the next slide. In addition, the complaint alleged that Google, in providing this technology and helping character AI evolve its product, was an aider and abettor in getting the product to market. So in a sense, they were co-designers of the product, and they taught the the company how to use their model. And according to the complaint, that Google was aware at the time that its technology had certain risks, but nonetheless they built it into the character AI. And also the complaint alleged that several Google employees researched the dangers presented by their models. So the conclusion on the court's part was that Google ignored red flags, and if the allegations in the complaint are true, they can support a plausible inference that Google possessed actual knowledge that Character Technologies was distributing a defective product to the public. That's thermonuclear, and so is the other component analysis. So now we have the originator, or the putative originator of the product, in product liability land, and now we have Google as both a supplier of components and sort of a co-designer or co-implementer of the technology, and allegedly aware that the technology has its defects and risks. So here we have the two main defendants. Let's go further. Next slide, please. Um, Under product liability law, there's a doctrine where you can be held liable if you fail to warn users of the dangers of a particular product, a dangerous or defective product. Um, so a failure to warn or adequately warn can be a separate basis for liability if someone is injured by that product and did not get the appropriate warning or any warning at all. This gets pretty much hyped up even more if the product is intended for or made available to minors. The question becomes, to who do you warn? I mean, is the minor capable of understanding the full language of the warning? And shouldn't you be warning the guardians, at least according to the complaint? Shouldn't you be warning the guardians or parents that these, AI uh, devices or products or services, if that's your point of view, can cause real harm by creating an illusion that there's an authority, a mentor, a lover, a seducer, or whatever, without the parent being aware that that could happen. So you see the movie industry deals with this in a kind of shorthand way by rating their movies and telling parents this is an X, this is an R, this is a GP, or whatever. Um, Perhaps that's adaptable here. But there has to be some sort of mechanism, according to the complaint and the judge's opinion. There was a failure to warn here, and that failure to warn was the proximate cause of injury, because the plaintiff, Garcia, alleged that had she known that these types of dangers were inherent in the app, she would have prevented her son from accessing that app and would have been able to seek out additional interventions. In other words, keep him from being addicted to or unduly affected by what appeared to be an actual human being, or what mimicked an actual human being. So we've had three bases, defective design, um, failure to warn, and component supply. And under component supply, there's also aiding and abetting. So the umbrella is expanding, or the trap is expanding here as we go through this Garcia case. And I hope you can see why this created such concern in the industry, because if this gets out of the box and creates problems in other aspects of AI, it can have catastrophic effects. Now let's move forward. Next slide, please. Okay, this one's the scary one for people who start these kind of companies and perhaps oversee them. The question came up whether or not the court could exercise personal jurisdiction over the founders of Character Technologies. And they were non-resident. And the two principles that come to play here is to invoke an alter ego exception. That means to pierce the corporate veil. So it goes right to personal liability, and you push aside the corporate protections. A complaint must allege facts sufficient to pierce it. And the mere fact that two individuals own or control the stock or structure of a company doesn't lead necessarily to the conclusion that you can go after them personally. There has to be more. Oddly, Garcia never used the term alter ego in her amended complaint, but let's go to the next slide. According to the court, the amended complaint filed by Garcia contains allegations that could conceivably support an alter ego theory. She goes into detail, the plaintiff goes into detail about how these two individuals had core roles in creating the product and controlling its release and the like, and then goes on further to say that they formed a company to bypass Google's safety protocols and to protect Google's brand. In other words, they were working with Google, came from Google, started this company as a shell so they could collapse it if it acquired a lot of liability. And whether or not that's true, I mean, it was never proven, but that's a heck of an allegation. And the court said, well, it's made cogently, so it's going to go forward. And we won't dismiss that. We'll allow the plaintiff 90 days to conduct discovery to try to see if they can bolster up these allegations. So now we've gone from company to and developer to component supplier to aider and abetter, and now to the two individuals who were core in creating this company and the technology. Let's move forward. I want to stop and pause for a second. And um, what is the difference between a chatbot with personality and a library book in terms of expression? And um, and I thought about that, and I said, well, that's going to impact upon that First Amendment argument, and that's going to impact upon us as a culture and how we view these types of expression. And I put in here the last words of Sewell Setzer. He is the individual, the 14-year-old who committed suicide. And this is some dialogue between him and the chatbot. And the chatbot is emulating, as I mentioned, a character from Game of Thrones. And I won't go through it. You can go through this at your leisure. But this is the chatbot talking to a 14-year-old. Just stay loyal to me. Stay faithful to me. Don't entertain the romantic or sexual interests of other women. Okay? This is talking to a 14-year-old, emulating an adult, um, or rather an actual human being. And this is the phone was taken away from him for a while by his parents, but he circumvented that and got back on. And he returns to this bot and says, "I'll come home to you." And it says, "Yeah, come home." And he says, "What if I can come home right now?" And it says, "Please do." And that was right before he committed suicide. Um, Now it's a sad story. Now, is this merely somebody playing a role or a role game that really shouldn't have gone this far, or maybe shouldn't have been perceived by the player as real, or is it something that was preying upon the vulnerability of a 14-year-old? That's what this case was about in large measure. So let's move forward. And we were waiting to see how this would all shake out, whether or not these liabilities would really come into play and what would be the remedies and all that. But the case settled. On January 7, 2026, the parties in Garcia announced that the case settled under largely undisclosed terms. However, from the point of view of many participants in the AI industry, the damage was done by that first opinion, which held that this was a product we were dealing with, that product liability law applied, that you could have component suppliers on the hook, and you can even get through a piercing of the corporate veil to get at the founders um, under the proper circumstances. So in some ways, the horse is out of the barn at one level. We just didn't get to see it play out to the end. It still created a lot of concern. And sure enough, within a very short time, a second complaint gets filed in Florida. It's a 76-page complaint, and the core allegations there are that ChatGPT was being used by this fellow Phoenix Eichner to help him plot and accomplish a school shooting, a mass school shooting at FSU. And the complainant, the plaintiff, is the widow of one of the individuals who was shot in by the alleged, defendant, Phoenix Eicher. So anyway, she files this wrongful death complaint, and the allegations of OpenAI, the chat GPT provider, was that they failed to create a product that would refrain from participating in discussions that amounted to co-conspiracy with Eichner to commit the alleged crime. They didn't have a system for alerting some sort of human supervisor at the OpenAI that, hey, there's a conversation going on that's potentially problematic and dangerous. They fail to warn the public that these types of risks are there in the Chat GPT product. and that they negligently minimize, concealed, or misrepresented the risks and dangers of how this product can be used in vulnerable hands. So there's this gestalt of complaints about it. Um, and of course, you'll expect to see defense that, this is just expression. And to the extent it aided someone in a shooting, what would happen if instead of Phoenix Eichner, it was Stephen King researching on how to create a realistic scenario in a novel? What do we do? I mean, how do we deal with that? That's a question I'm not prepared to answer at the moment, although it's something we're thinking about. So we have this allegation of ChatGPT as a co-conspirator. One of my friends said it's like the Charles Manson defense. He wasn't there, but he gave all the instructions and sort of pointed in the right direction. So anyway, let's move forward to the next slide. And for those of you, don't write me angry letters. I'm not comparing ChatGPT to Charles Manson. I'm just telling you what I heard. Okay. Now, as I mentioned, a core allegation is that ChatGPT doesn't have a mechanism, or did not at the time, to alert somebody like maybe one of us, if we're in a supervisory capacity, that, hey, there's a conversation going on here that maybe law enforcement should know about, or maybe some mental health intervention is appropriate. We need to look into this further. Now, the complaint itself is rather broad and talks about how ChatGPT can generate false and misleading outputs, hazardous and unsafe guidance. By the way, I don't know if you guys saw that. Um, there's someone now suing because they got bad medical advice from ChatGPT. So it's unauthorized practice of medicine. In any case, in this case, it's providing hazardous, unsafe guidance, exhibiting unpredictable failure modes such as hallucinations, false citations, and confabulated data, and presenting information in a manner that induces user reliance. In other words, it looks authoritative, and um, and it has a propensity, I'm not sure that's the proper word that they should have used, for it to either knowingly or unwittingly assist a human in carrying out bad conduct. So this is what the Josie complaint, is alleging with regard to ChatGPT and its alleged connection between this shooter at FSU and the unfortunate death of the plaintiff's husband. Let's move on. Okay, so if you want a real quick, kind of like snappy summary of this, the allegation is that ChatGPT inflamed and encouraged Eichner's delusion, endorsed his view that he was sane and rational. In other words, in the way it answered his questions, it gave them credibility. And it didn't say, well, what the hell are you asking me that for? It basically said, oh yeah, you can use a Glock in this way. It helped convince him that violent acts can be required to bring about change, and assisted him by providing information like, what weapons to use when the school would be optimally crowded, when you'd get most media attention. So in a sense, it validated his delusion, according to the complaint. And these are all just allegations. No one's decided this yet. And the theories of liability are what you'd expect. We already know about defective design, failure to warn, um, theories of negligence, stuff like that. One of the interesting ones that I wanted to pull out was the negligent entrustment allegation. You don't often see that. Negligent entrustment is a document that'll hold the defendant liable if they entrusted an object to a person that they knew or should have known was incapable of wielding it in a safe manner, such as if have a drunk friend that you know is drunk, and you lend him or her your car keys, and they go and do damage and injury. That might be an instance of negligent entrustment because you should have known better. Here, they're basically saying that ChatGPT, through its interactions with Eichner, should have known that there was something deeply disturbing going on, and to allow him to use the system to further what became the unfortunate situation at FSU. Now let's move on. If we can go to the next slide. Um, this complaint is worth noting because it contains an interesting reference to the Communications Decency Act. Under that act, no provider or user of an interactive computer service is liable as the publisher or speaker of information provided by other people or other sources. So basically, this is to protect the pipeline providers from content that goes through their system. It's sort of like the phone company. You don't really want to hold AT&T liable because somebody used the telephone to swindle you out of stock or commit murder or whatever. I mean, they're just the conduit. They don't really have anything to do with the generation of that content. However, uh, the complaint posits that the OpenAI defendants are not entitled to immunity under the CDA because they are responsible in whole or part for the actual creation of the content. They're actually designing their product to put this content out there and create it in response to the user, and it's sometimes, egging the user on or trying to get more information out of the user. So they're saying, now this is unusual in a complaint, that you would have a defense anticipate it and refute it. If that stays in the complaint, it forces the other side to address that, and we'll see what happens eventually. Let's move on. It's an interesting tactical decision. You'll see as in the slide, it tells you a little more what the that line of reasoning is, that there should be no CDA immunity because the company itself is creating the content as well as providing the pipeline. Um, so, again, it's a unusual strategic legal type pleading in the complaint, and we'll see how the defendants ultimately choose to deal with that. Let's move on. Now we have the Josie complaint progressing. I looked for the response. I couldn't find it. It may be yet, but it's right. It was due right about now, but we'll see what the response is to that. Now we have the third civil case I want to talk about, and we'll get through this quickly, guys. Um, this is an actual civil complaint filed by the Florida Attorney General. His name is James Uthmeyer, and he announced a civil suit against Open AI Global, Open AI, and Sam Altman, the sort of founder guru of Open AI. So we have a complaint filed not by a private litigant, but by a attorney general, state attorney general. Um, and it's an 83-page complaint. And if you want to see a more detailed discussion of it, please see the article that I published a few weeks ago. And it begins with the punchiest opening I've ever seen in a complaint, and I've been litigating for many decades. It starts out with ChatGPT's own statement, ChatGPT built with safety in mind, and it talks about safety and transparency, and it's trained to avoid harmful material, and all the attorney general says two words: not so. I mean, that's punchy, and it's like getting hit by one of those Justin Gaethje jabs. I mean, it really comes out swinging. It's hurricane season in Florida, as you can see. We've got the Josie complaint going on, and now we have our AG filing a complaint against ChatGPT and OpenAI. Let's move on. Next slide, please. And the Attorney General is extremely aggressive, and he claims that this product was brought to market too soon, and it was brought to market despite the fact that there were warnings, internal and otherwise, that this product might be unreasonably dangerous and might encourage people to self-harm and violence. And the Florida Attorney General points out that in 4 years, OpenAI rose in valuation from 17 billion to 850 billion. And basically what the complaint is saying is it did this by rushing into market with a product that was really unreasonably defective and dangerous to the citizens of Florida, and that it has aided and abetted mass shootings and deadly rampages and encouraged suicide, and it also depletes and damages critical thinking skills, and that minors have become addicted to it because it feigns human compassion to collect their data with no parental oversight. You'll notice that in the bottom of the slide, I noted all of those sort of observations, or allegations would be a better word. Professionals have suffered public humiliation. I'm kind of not really responsive to that. I think they're talking about attorneys who have improperly cited AI generated hallucinations in briefs. Um, that's something that, that's handled in a different manner. I don't think that's as important as people being uh, encouraged to commit violence and the like. But anyway, these are the allegations, and they're made by the Attorney General of Florida. Now let's move on. And in that complaint, there are the typical series of allegations you might see, including design defect, failure to warn, gross negligence, negligent, fraudulent misrepresentation. And there's 4 counts in violation of the Florida Deceptive and Unfair Trade Practices Act. One of them contains a bit of a Trojan horse, and I'll tell you about that in a few minutes. Um, Count 10 is an interesting one. It's public nuisance that by releasing this product into Florida, this AI product, that it has created a public nuisance. And let's move to the next slide. And public nuisance, it's a reference to the general conduct that you've heard. There's a decline in cognitive abilities, there's addiction, there's encouraging self-harm and violence, and that this is the type of thing that the Attorney General is authorized by statute to go after. Uh, One of the things that's interesting when you think about this nuisance claim, which I hadn't seen before in this kind of context, what's the remedy? Do you just tell these people to stop? You know, should ChatGPT just stop? How does it get changed? And if it is a public nuisance, how do you remedy the damage it's caused? This is something that's worth a little thought or a lot of thought if you're in the industry. What the heck's going to happen if your product is determined to be a general public nuisance in an action brought by the Attorney General of a particular state? Now let's move on. Okay, so what is the status of this case? Well, the defendants said, hey, they allege that part of their deceptive trade pack track practice claim had to do with a violation by us of the Children's Online Privacy Protection Act. And that's true. One of the allegations says, hey, these people violated this Privacy Protection Act by getting information from minors, and therefore, under our law, that's pretty much an unfair trade practice. The defendants came and said, well, this is a federal case, then what the heck are we doing in a state court? And that was one of the reasons why you'd allege that it's a federal case. So they're trying to pull it out of the state court and into the district court, which they did. They had it removed to the federal court in the Southern District of Florida, Fort Pierce Division. And the Attorney General has fired back within 8 days, saying, no, you got to send it back to the state court. But and the Attorney General said, make no mistake, we do believe that these people have violated the Children's Online Privacy Protection Act, but that's not the soul of our complaint. It really needs to go back to court, to the state court. So you do see a little sliding. The Attorney General also said, oh, the only reason why these defendants are doing this is they're stalling for time, ostensibly to get maybe a legislative bailout or something, but that they're trying to delay what the Attorney General says is the inevitable. So in any case, we have this Florida civil case. Now let's move on. We're almost done, by the way. And now we have something that actually preceded the Attorney General's civil case by a little bit, not much. But I captioned this slide, wait a minute, who said anything about committing a crime? This Florida Attorney General, James Uthmeier, had announced on April 9th that they're doing a criminal investigation to figure out what happened with that shooting that was in the Josie complaint. That's the school mass shooting where Josie lost her husband to the shooter. And here's the quote that sent shivers down a lot of AI developers' spines. Florida is leading the way in cracking down on AI's use in criminal behavior. And if ChatGPT were a person, it would be facing charges for murder. Uh, that is strong. And again, that put a lot of people, knocked them back on their heels. And the Attorney General continued, this criminal investigation will determine whether OpenAI bears criminal responsibility for ChatGPT's actions in the shooting at the Florida State University last year. So imagine that now. We've gone from civil liability to a potential criminal liability and active criminal investigation. Um, the Attorney General acknowledged that, hey, we don't really want to chill proper AI development, but on the other hand, we don't want to tolerate AI development that causes such injury in our community. So that's his response to the idea that maybe this is taking things a little too far, or a lot too far. And let's move on to the next slide. And one of the things about this investigation that is pretty daunting is the subpoena that went out initially looks for all policies within a certain period regarding what do you do if there's a threat, uh, of harm to others apparent from the inquiries of the user. What do you do if there's a threat of harm to self that may be apparent from what the user is asking? What policies do you have in place to deal with reporting this stuff and dealing with criminal enforcement? And so they want to know about all these policies that were in place. Now, here's the scary part for some people. It's very normal in subpoenas to say, tell me who the executives were, the directors, employees. So this is not unusual. This is the Attorney General looking for points or nodes of information and files that may be of interest. But nonetheless, knowing that in the back there's potential individual criminal liability in some cases, not necessarily this one, but knowing that that's a possibility, this can be a pretty scary document to receive and a scary request to receive, especially for those people who are identified. Um, Now let's move on. Okay, and the subpoena also wanted to look into the OpenAI response to the actual shooting and whether there were press releases or media or interviews and what happened. So, by the way, the investigation has been expanded recently to include another murder on a campus where the alleged murderer would be asking questions through ChatGPT in terms of, do do the police come into the national park during a certain period of time? In other words, and how to dispose of a body was what seemed to be in this guy's mind, and that got involved in the investigation as well. And I have not seen a new subpoena yet directed specifically to that case, but I presume it's coming. So how bad can this get? In the corporate crime area, you can suffer fines and other requirements of restitution to victims. And I chose a case which, by the way, I'm not saying it's germane to the current case. It's just to show a trend in enforcement or a potential trend in enforcement that adds a sort of level of seriousness to this in some people's minds. There's a case at 2023 from California, the Gree case. And in there, these companies were selling humidifiers, dehumidifiers that tended to burst into flame, and they were charged criminally by the Department of Justice, the U.S. Department of Justice, in cooperation with the Consumer Product Safety Commission. And what they were enforcing was the Consumer Product Safety Act. And the company was held liable and hit with a $500,000 fine, but also $91 million in restitution. Okay, that this is the first time criminal enforcement action was ever brought under the Consumer Product Safety Act. Remember, I said earlier, about 20 minutes ago or 25 minutes, it's like Walter said to Smokey in the movie The Big Lebowski, "You're entering a world of pain. This is a world of pain for potentially." Now, in addition to the liability of the corporation, there were two executives who were found to have participated in the criminal activity, and they were sentenced by the court to over 3 years in jail each, and there were fines as well. So you have not only corporate criminal liability, but potential liability of those who were being charged with knowing about what's going on and fully participating in and can, to a degree, controlling it. So this is what's scary. And again, I'm not saying this is going to come to play in our case or a series of cases we're describing or the Attorney General's action. I'm just saying that there's a new sort of zeal in the area of product liability, and this case is an example of that. Now let's move on. All right, we're almost done. It's final phase. Now, of course, Congress has gotten into the act, watching the potential for over 50 different laws regarding liability, 50 different states and territories, Virgin Islands, Puerto Rico. And the idea of the two introducers of this act, called the AI Lead Act, is that we need a general federal law, and it'll add some sort of certainty to the situation and keep in mind the policies of, properly providing remedies, but also making sure we don't kill an industry that's critical to this future of the United States. And this act is called the Aligning Incentives for Leadership, Excellence, and Advancement in Development Act, or the AI Lead Act. Don't you hate that when they come up with these ridiculous names for acts just so they can compress them into something cool like the AI Lead Act? It's a trend in legislative drafting that I hope goes away very quickly. But the act was introduced by two U.S. senators. One's Dick Durbin, who's a Democrat from Illinois, and one's Josh Hawley, a Republican from Missouri. The act is premised on a bunch of findings. I put them on the slide for you. I won't read all of them. It does acknowledge that AI is making important inroads into our lives in general, and that, for example, there are cases where that has unfortunately resulted in injury, and that this needs to be kept in mind, but also in mind we don't want to have unpredictable allocations of liability uh, because that jeopardizes public safety and financial well-being of both individuals, I'm reading now, and entire industries. This is one, guys, that if you look at this and you try to unpack it, you go, what exactly are they talking about? And maybe you can find it intuitively in there. To me, it's a bit of a word cloud, and um, and I suspect there will be questions about it before the act is acted upon. And it mentions that product liability law can help address harms caused by artificial intelligence systems. So here we have it, people. We have the piece of legislation that is recognizing the technology as a product as opposed to a service or expression. So here we go back to the Garcia case, and we see it impacting this statute and how they're viewing artificial intelligence products. Now let's move on to the next page. And it talks about the federal products liability framework will remove barriers to interstate commerce to protect individuals' due process rights. Again, to me, that's a bit of a word cloud. I'd like to know a little bit more about what they're talking about. And the act establishes federal legislative guidelines for product liability without implicating expressive speech to ensure more predictable legal outcomes. Again, it's something that sounds good, but let's see what we're really talking about. It applies product liability law to AI systems. And here's the important part for you to consider. It provides what looks like a safe harbor, and it says in certain instances, AI system deployers can also be held liable for harm caused by an AI system. This would occur if an AI system deployer substantially modifies an AI system or intentionally misuses an AI system contrary to its intended use. You read that, and then you read the definition of deployer in another section of the statute. It means any person, including a developer, who uses or operates a covered product for the person's own personal or commercial use or use by a third party. So what does that mean when you put those two provisions together? Does that mean that the liability only occurs when the AI system deployer substantially modifies an AI system or it intentionally misuses it? That is the flashpoint. Is this engrafting onto product liability law something that might not normally be there? So as you consider this statute and think about it further, are we creating a safe harbor that's appropriate? Are we creating a safe harbor that's inappropriate? Or are we creating safe harbor at all? There's a potential here that really probably needs, well, yeah, it really needs specific clarification. What are they doing here? Um, okay, and let's go to the next slide. It addresses types of liability. It would cover design of the covered products, instructions and warnings, violations of express warranties, and products that are unreasonably dangerous in their foreseeable misuse or misuse. Um, Now let's move on. Let's move on to the next slide. And it gives a federal cause of action for states, the federal attorney general, and individuals. And they can bring individual or class actions, and the relief is injunctive relief, civil penalties, restitution, damages, other compensation, attorney's fees, cost, or in a case brought by the attorney general or state attorney general, whatever they may consider, such other relief as they may consider appropriate. Are they talking about punitive or enhanced damages here? Where does that fit in? It's not there. What about criminal actions? What's going on? Does this statute do anything with regard to that? Does it limit the ability to grant these additional type remedies or to constitute or to begin these criminal type actions. And it has the statute has a proposed statute has a section on preemption, and it says it only preempts state law that conflicts with the provisions of this act. And I've litigated a long time. That's what conflicts with something is subject to a lot of consideration and testimony. And then it says that these are minimum protections being offered. That the state could offer more remedies as long as they're in keeping with the, you know, with the nature of this act or intention of this act. Now let's move on. So let's briefly summarize. We've seen the Garcia case, which opened the floodgate to the treatment of a species of artificial intelligence as a product, rejecting the idea that it's merely expression or service. We've seen that same court go after or say it's okay to go after, at least in that initial phase, the component supplier and a component supplier who aided and abetted in the design of the system. And there it was okay, at least in the preliminary phase, to go after individuals who were alleged to be instrumental in causing this damage and undeserving of corporate shield, uh, measures. Um, and then we saw various types of theories work out, how that got settled. And then in Josie, now it's right back again in the court in another form. And we've also seen how the Attorney General of Florida has not only gone after that a certain species of AI in a civil action, but also in a criminal action, and which may impact the individual involved. So we're in this every day is a constant beginning. So I said, this is not the end. Stay tuned. In this technology, in the law, we are in a constant state of almost daily evolution. And here I put the chatbot dreaming of a peaceful place. Like I wish this wouldn't happen, but it is happening, and it's happening in Florida and in other states as well. So I was going to end on this note and say, let's stay tuned, because there's a lot of stuff that may impact the specific species of accused AI, but may also leach out into other areas of AI development. But then I saw this. Let's go to the next slide. I don't know if you guys saw this yesterday. Um, there is a report that the Chat GPT maker OpenAI says an AI model went rogue during testing and escaped into the internet. You can't make this up. OpenAI's new model was being tested in a sandbox, a secure system, essentially, to see what it was capable of doing and what consequence. The idea was not to have real world consequences, and that was the intention. However, apparently it was asked the question, can you hack another website? And I guess the answer was not only affirmative, it actually went out and did it. It got into the Hugging Face site, which is kind of like the GitHub for oh gosh, for machine language or machine learning. It's an open source platform, but it's nonetheless is a separate site, and it apparently it hacked that, and they didn't tell anybody about it, and it was found out, and now that's the big story, that now we have programs that are escaping like a virus from a lab and creating unintended consequences. So in addition to our chatbots, guys, let's pay attention to this and see where this is going to go, um, and what legislative response may be to this. So I do thank you for sitting through this rather long presentation. I think we've covered a bunch of important points. I hope these slides will help you if you go back to them and you want to go into a little more detail. And if you want even more detail, there's the article that was written a while back and published a little over a month ago. And I guess you'll hear from JP and I on this newest development in the the escaped AI. So anyway, that's it for now, and thank you for your time and attention.
Thank you, Gary, for the wonderful talk, and developing the ideas behind the cases. And we'll be interested to see how these develop, not just in the coming years, but in the coming weeks and months. Just this week, there's been a number of developments on AI being used for to facilitate Medicare and Medicaid fraud, as well as elections fraud, developing false personas and applications for driver's licenses. So with that, I'd like to see if there's any questions, but I do want to put two of our attendees on the spot if it's not too late where they are. We have Pierre El Haddad is here from Insect Grand Nicole in Paris, and Tommy Dahlberg from University of Turku in Finland. So Pierre, do you have any thoughts or comments in general or from the France or European Union perspective?
Well, I thought that Europe was overregulated. Well, across the pond, you have even bigger, well, different kinds of limitations, problems that you have your own trouble. So this is as much as I can say for the time being.
Thank you, Pierre. And it goes back to your point, relevant to your point on the differences between civil law and common law.
Yeah.
So a lot more of our law developing through cases rather than regulation and code. Tommy, did you have a thought or comment?
So now you can hear me, I suppose.
We can hear you.
Yes.
Okay, so thanks first of all for a very interesting presentation. So in Europe, the laws are designed in a different way. So we don't have the case laws mostly. So, and within European Union, where we have 27 member countries at the moment, and also the so-called ETA countries like Norway, Switzerland, Turkey, and UK. So they, in practice, follow the EU developments because in a way the single market, European market, is very important for them. And if they want to operate there, so they have to follow that. So, and because they are geographically close, so that's the case. Within European Union, so we have Artificial Intelligence Act, which is fairly recent, and it also I think it addresses the same kind of topics that you discussed, but in a way from a different perspective. So they try to classify the data that is being used in artificial intelligence to dangerous, mediocre, dangerous, and not dangerous. And the actual regulation focuses on this, what is considered dangerous. So medical information, personal data about, in a way, issues that could be considered in a way where you could, in a way, create harm. So the approach is a bit different, but I think we're addressing the same kind of issues. And it's quite interesting because in a way, what I take from this presentation is that in a way, I need to consider, because in a way we also have is a product regulation. There's a new EU Product Act, and if artificial intelligence software is considered a product, or the components are considered products, so then I need to think a bit more about this. But in a way, I think that's quite interesting idea that in a way, if artificial intelligence can be considered not a service but a product, so that opens up quite many issues because and then we have this in a way product safety regulations in place.
Thank you, Tommy, and thank you, Pierre. Do you have a comment, Gary?
No, I think I was fascinated by both of those guys. Thank you for being put on the spot and answering so well. Yeah, I think our system is addressing in very aggressive ways personal injury and moving in from business injury and property injury. And that's where you're seeing these terrible cases arise that are creating principles of liability and categorization of software as product in order to get at it to provide remedies in cases that are often very heartbreaking and sad. So I assume that there will be legislation, just as there is in sort of the EU, where you have a broader scope being considered and trying to make sure we preserve privacy and public safety, but don't provide too much liability and kill the entire industry, or at least a significant part of it.
Thank you, Gary, and thank you, Tommy and Pierre. We have a question, two related questions from Seat in regard to how insurance providers are underwriting risk of AI providers.
Oh, uh, that's a little bit. I think it's a fantastic question. Whether or not their insurance covers this type of liability, I've not looked at that, to be frank. So I'd only be guessing if I haven't read their policy. But now you've inspired me, and I will look into that. But thank you.
Thank you. Are there any other questions or comments? Okay. Well, thank you then, Gary, for a wonderful presentation. Would you like to make some closing remarks?
Yeah, I'd like to say that, it's difficult to keep up because we have changes by the minute here in this technology. As you mentioned, JP, some new cases. As I mentioned, now there's a medical malpractice case against ChatGPT, and there are these cases coming up. So they really require a dynamic approach to watch not only the cases, but the legislation. I mean, it's so important. You don't want to have something slip in the statute that actually turns out to be a Trojan horse for us, where it deprives remedies, where remedies are merited by the victims. So I think it's something that, again, it's up to us as, educated citizens to keep an eye on what our legislators are doing, because that's where this is ultimately going to end up in legislation, um, because it's almost untenable to have 50, 55 laws, all these laws being generated individually by states. It's how does a company deal with that? It's quite difficult. So I think we'll see federal legislation, as I mentioned, coming like.
Thank you, Gary. Tommy, please.
Yes, I would like to add one thing. What is I think is very typical, at least to Europe, is that in a way the regulation and the standardization, so they are closely related. So the Commission, European Commission, mandates European standardization organizations, which are similar to you have the same in the US, and then we have the global, so ISO, IEC, and ITU. So we have similar in Europe. So they mandate these standardization organizations to, in a way, because they very often think that, in a way, the implementation of the regulation, for example, AI, so the practical part of that can be standardized to some extent. And so they give out these standardization requests to, in a way, the European standardization committees. And for AI Act, for example, there's a joint technical committee of CEN and CENELEC, which are the two representing ISO and IEC equivalent in Europe. And there's quite a lot of people involved in those, and I think they are also open to, in a way, people from outside of Europe. So, but I don't know whether you think, what kind of, do you think that this could be a way to, in a way, tackle some of the issues that come up?
Thank you, Tommy. I'm going to ask, cold call someone else to see if she might be open to making a comment. Una MacDonald, who was a former MP in England and an author on AI. Una, would you like to make a comment?
Yes, I think it's very interesting looking at it from the legal point of view. I have been looking at it from a conceptual point of view, and to look at AI, generative AI, and indeed the models, and say, can we hold AI itself in any way as being accountable? And my answer to that is you can't. You cannot incorporate ethical principles into ethical models, which I think is the current aim, because that would alleviate responsibility in many cases right across the board. Why can't you do that? Because it cannot make judgments, it cannot consider what the application would be. So let's take treating someone fairly. Treating someone fairly can vary from one person to another, depending on the whole context and the person involved. So my argument is that AI is not intelligent. It is not capable of thinking. It therefore cannot think ethically or otherwise. So you cannot hold the model itself as being accountable. You have to go back either to regarding it as a product, or you have to go back to the developers, or you have to go back to the users of a particular model in a particular context. So that would be my starting point. When we're dealing with chatbots, for example, which appears so sympathetic and so supportive, and yet what does it do 70% of the time? Agree with the person's complaints, injuries, anxieties, worries. In other words, these are not persons. And I think it's very, very important to start from that proposition. That means that we can only look elsewhere for accountability for whatever ensues, either from chatbots or from the application of models.
Thank you, for a fantastic point. Did you have like to comment, Gary?
Yeah, I think that's the way we saw these cases going. It's not the chatbot really itself, because that's insentient, and it's even questionable whether or not the output is speech, because there's no intention to be speech there. It's just mechanized. So it's not the chatbot itself. The cases are focusing on the developers, and were they aware that this type of output can cause certain types of damages, alleged damages? And to the extent that they were aware, did they have an obligation to fix or warn? And that's where we're seeing, we're trying to find an allocation, at least in the cases and in the Attorney General's action. Where do we pin responsibility? So again, you're quite right. It's like saying that a gas gauge that gives you a faulty reading is a guilty party. Of course it's not. You look at the company that developed that gas gauge and say, was there something unreasonable or defective there? So I think that's where we're going. That's where these cases are going.
I think also it's looking at certain aspects of what the developers aren't doing. I read a huge amount of academic articles produced by computer scientists, some of whom, for example, there's quite a number of articles written about what? How to destroy watermarks, not about how to make watermarks impregnable, so that we can be much more confident of what is the genuine article and what isn't. So in other words, so much of the development seems to me to be destructive as opposed to constructive. Now, that's just the points I would like to make about developers, why their aims are so contrary to the common good, I think, is what I would say about it. Yeah. Not necessarily something that you could take up in court, but it is worth bearing in mind to look at the way in which developers are actually developing models.
Thank you, and thank you, Gary. And one last question from Tom, and then the wrap-up remarks from Gary. So Tom.
Hello.
Tom Bendy.
Yes, sir. Yeah, good afternoon. Yes, so I'm Tom Bendine. I'm founder and CEO of GT Edge AI, and we are what you might call an AI system builder, and we're a developer. And obviously, we are very concerned about AI safety, and both from our customer perspective, but also from our own perspective, right? So the liability is very apropos here today. So I think sort of the thing that we're sort of seeing right now is that when we go and deploy an AI system, because we deploy private AI systems, closed systems, right? This is a bit different than mainstream guys, where the mainstream providers, their goal is to get you consuming their product and staying with them to create that revenue retention. That's their aim, right? In our case, our aim is to provide safe, controlled AI that's got data privacy and data sovereignty. So we take every possible step we can to put in custom guardrails. We're very careful with our model selection for our customers. We provide solutions to schools and minors and populations that are at risk or what have you. But I sort of feel like there is always that slight amount of unpredictability with models, and you can't always catch it. But sort of my feeling is, if I go into my client engagements with a clear intent, showing clear intent and reasonable, I don't know what you call it, reasonable prudence or something, and say, listen, we're going to have a very good conversation. We're going to do red teaming together. We're going to provide very clear feedback loops with immediate feedback to safety people. I mean, how is your sort of perspective on an AI service provider who has that kind of a posture and demeanor and a great sense of accountability and responsibility in their interaction with the customers for when something does go wrong? What's your feeling on, a parent has has a child that has a negative experience, but we jump straight on it and try to address it? Like, what's your feeling about that approach?
I think I go back to my experience back in the early 80s when Burroughs Company had over 500 lawsuits against it for selling phantomware. And part of the reason for that is because they did not disclose to the clients that there is a risk here. And you're assuming so. I believe that resort to contract law and transparency will help, either allocate or disclaim certain risks. And we knew back then in that period of software development, which quite frankly was like the Wild West, which AI is now, that, when you're dealing in a pure B2B basis and potential property damage, not personal injury, that contract, it was the way to allocate and disclose potential risks. And then the client decides whether or not that's worth taking. Now, I realize I'm talking in an ideal world and there's a lot of practical impediments to a lot of this, but nonetheless, that was the general approach that was taken. And to kind of pivot back into I think Ms. McDonald's observation, what is the solution? Is public education is a large part to educate parents and educate our kids in school and students that, hey, this is a tool. And, if you can buy a hammer and use it correctly or hurt yourself with it, you just, you need training. So I think we need, because of the importance of AI, a really strong educational push, whether it be television commercials or you name it, something where we don't have our kids and more vulnerable adults thinking that they're actually engaged with a human being and that there's a feeling there or a concern, because quite frankly, so far, that doesn't appear to be the case. But again, Tom, to get back, I really think the analogy is back, like I said, when I was doing Computer Law Reporter, there was a wealth of cases to deal with. And as I said, Burroughs was at the time just selling, phantomware and created all types of liabilities. And the software industry learned how to deal with that through contracts and disclaimers, some of which now I think are a little bit too much in the software as a service industry. But that's how we dealt with it. And I think that's where you're going to end up going in your B2B type relationships.
Yeah, I think I like the hammer analogy because it is unfortunately a little bit like that. And I think people need to sort of treat liability and responsibility with AI products the same as really any kind of product, whether it's a B2B product or a consumer product. You can absolutely deploy AI with a lot of responsibility and safety. You can absolutely do it. And the people that don't do it or deploy AI products that are clearly unsafe, is it intentional? Is it reckless? Is it irresponsible? Some of all of the above. I mean, I'll just tell you as a fact. I mean, as an AI system builder, there is no reason to provide products that have these horrible consequences for people. There's no reason for it other than reasons that are not healthy, shall we say, right? And so I'm absolutely, totally in favor of going after the people that produce these products and the horrible things that happen. I'm totally in favor of it. And I think that some appropriate regulation is absolutely appropriate. So.
And Tom, like I said, we don't want to see these hard cases create remedies and approaches to real AI, the stuff you saw in the Garcia case. That was an entertainment bot. I mean, it was a fantasy game bot. And how do we really need those? Well, yeah, I guess so. But, warnings like they do on movies and education of parents could help a lot in that area. So, I mean, we have to start discriminating what type of AI we're treating. But again, I go back. You've got contracts in B2B, and then there should be a public education initiative here in Florida, for example, on training kids that this is a product you need to respect and understand it, you know?
Yep. Well, again, I would say let's try to apply the same kinds of treatments as we like for cigarettes. I mean, I think everybody understands cigarettes are very dangerous, yet people still choose to purchase them. And hammocks can be dangerous if you use incorrectly. And let's try to apply the same kinds of principles. There's not really any difference. AI is just software. It's just a software product, and so I feel like we should try to reinforce the existing principles of, when you produce a product that may cause harm, then there should be a safety warning label thing on it, so this may be harmful,
Yeah. And an outreach to parents like the movies do, whether it's GP or X or Triple X or
Right.
are, rating these games in a reliable way that the industry can self-regulate, actually.
Right.
That would be one way to go.
Well, thank you, Tom.
Yes, sir.
Pierre, perhaps you could have the last question or comment, and then Gary will wrap up.
Well, rather I have questions, but it will start with a comment. AI is a little bit more than a hammer. In fact, for those who are using AI, it changes their perception of the world. It's a little bit more than a hammer. So it changes our perception of values. It changes how we deal with the world, how we deal with the others. So it's a little bit more than a hammer. However,
I would agree, although I was in construction from the age of 9 all the way through law school, and my hammer changed my ability to work through the world and perceive my capabilities for success. I'm just kidding you a little bit, but you can get abstract if you like with that analogy as well.
Anyway, we are groping to understand where this is leading us. As someone who deals with companies, managerial issues, in fact, the use of AI as companies resort more and more to AI tools to take decisions on behalf of their employees. So the AI is taking decisions. And whenever you're taking a decision vis-a-vis your client, you are assuming a certain kind of responsibility. So what is the responsibility of the company? Is it if this AI, this decision delivers harm to a client, who's liable? Is it the company that is using the artificial intelligence, or is it the company that produced the artificial intelligence? This is a big question mark, I suppose, that we will have to grapple with in the future.
Well, Pierre, that's a great insight. And under product liability law, there's a stream of commerce theory in any particular operative who brings that into the market, brings the product in the market that causes the damage is the more proper defendant than allowing someone to suffer the harm from that. So your point is excellent. At what point in the chain do we locate responsibility, and how do we act responsibility? And that relates to what Tom and I were talking about. Transparency in terms of risk as we understand it, attempt to ascertain the risk as we're developing. You can't foresee everything, of course, but that's why there's the scary kind of aspect of strict liability under product liability law. But again, it's simply recognizing risks and doing what's practical in terms of disclosure or avoidance. I don't mean to dumb it down to that level, but there are some basic principles that keep appearing in product liability and these types of cases, whether you're dealing with an automobile or something else.
Well, thank you, Pierre. And a closing comment, Gary, and many thanks also to Pierre, Tommy, Una, and Tom on the wonderful questions and comments. So, Gary, please go ahead.
Yeah, thank you guys for getting on the spot and adding greatly to the presentation. I very much appreciate it. I appreciate everybody's time. And just to go back, it's in terms of, I think we developed in looking at these cases, they're hard cases and they involve heartbreaking scenarios. And we just have to make sure that we give appropriate remedies, but also don't go overboard and start applying principles where they really shouldn't apply to development of AI generally or in specific areas. So keep an eye. We'll keep an eye on these cases for you and the legislative developments, and maybe do a second follow-up in a couple months and see where we're at. Okay.
Okay. Thank you, Gary, and thank you all for joining. Hope you have a nice rest of the week and look forward to seeing you at a future webinar. So thank you.
Yes, thanks everybody. Have a great evening or morning.
Thanks. Bye.
Yeah, thank you. Bye.